Hello, everyone. The State Superintendent Elsie Arnson will be starting in a couple minutes. We are very pleased that you're joining us on a very snowy, wintry Montana day or evening. The agenda I'll be putting up on the screen here. I think I had it before. We have a good agenda for you tonight, and I'm very pleased that you're with us. So we'll be starting in about another minute. Thank you. Right, everyone. Again, this is Elsie Arnson. Thank you for participating in these. We do these once a month. This is sharing legislation that legislators put into play. And we've got an agenda for tonight. Dustin, going to get that up, the agenda. I know it was on the screen before. I'd like to introduce Rob Stutz. Rob is our chief legal. And we also have some other support that's happening here at the Office of Public Instruction. This is really an engagement discussion. Rob's going to talk a little bit. If you would like to interject, if you have a question or a comment, or would like some more clarification, just put that hand up, whether it's this hand or if it's that hand that reaches up on the Zoom screen, please do so. We want to hear what you have to say about this. We want to hear your understanding that we can move this thing forward. But it's about you. It's not so much about us presenting. So, Rob, I'm going to have you go ahead. We do have the agenda, and we are going to be discussing about House Bill 361.
Thank you, Superintendent, and welcome everybody. Glad to have you here as we go over two bills today. My name is Rob Stutz. I'm Chief Legal Counsel at OPI, also the Deputy Superintendent. And if you've attended one of these before, some of this will sound a little bit familiar. We'll walk through the process for how to find and read these bills. And the information that we're providing here is general information, as well as a community discussion, and it's not a substitute for legal advice that your own counsel may have for you. But Superintendent, I'm going to take over the sharing of the screen and walk through our audience and our participants so they can see the resources that we have available. I've pulled up the OPI main page. This is opi.mt.gov. And if you look down on the main page on the right-hand side, we have an area with parent resources. Clicking on that will take you to our parents page, and it has information about the similar community discussions we've had in the past, as well as the community discussion we're having today that the superintendent introduced. Two bills, HB 361, regarding the use of a name and sex by a student is not discrimination, and HB 504, board trustees to adopt a grievance policy. The agenda that the superintendent pulled up is available as a link on the web page, as well as a summary of the legislation that was prepared by OPI. I've already gone to the legislative website and pulled up information about these bills. If you would like to follow along, you can go to ledge.mt.gov, and there's a search for the bill, and you can just, through the drop downs, pick HB for House Bill and then type in 504, or you can just follow along on our screens. And similarly, you can open up for HB 361 from Representative Lear and follow the text of that bill, of both bills that we're discussing today. HB 361, both of these bills, in fact, have pretty limited changes to Montana law. Some of the bills that we've done during previous community discussions have spanned dozens of pages, but this first one, 361, has a very small change. You'll notice here that it is not in Title 20, which is typically where you find most school laws. This one instead is in Title 49, which is where the Human Rights Act and related discrimination codes are codified by the Montana legislature. So it's an amendment to 49-2-307 regarding discrimination in education. And the change that we're going to be reviewing today is the addition down here of this subsection 2. They've renumbered the law so that there are some non-substantive changes, but really the substance of this provision is here in this new subsection 2. And the information is pretty straightforward. For purposes of this section, is not an unlawful discriminatory practice for a student to call another student by the student's legal name or refer to another student by the student's sex. Some context here. First of all, this is regarding discrimination in education. And so you can see the reference here to it occurring in an educational institution. This is both primary and secondary education, and also includes post-secondary education. And one of the things that we need to keep in mind is that an institution only acts through people. For example, if a student or an employee of the institution were to behave in a particular way, or if the institution were to allow them to behave in a particular way or prohibit them from behaving in a particular way, that's what this statute gets to. So when we're looking at this section, and let me just enlarge it here a little bit. I know that it over the Zoom, it might be a little bit harder to see. So what we're looking at here is the addition of just a few, one sentence with a few provisions in it. It's not an unlawful discriminatory practice for a student to call another student by the student's legal name. Well, let's stop there for a minute and discuss what what that might mean. And as the superintendent noted, please, if you have any questions, you can save them toward the end, or you can just raise your hand and ask them as we walk through the bill. So everybody has a legal name, and there's the ability to change an individual's legal name. But this section states that using that legal name is not an unlawful discriminatory practice, or from the perspective of the educational institution allowing the use of that legal name. Similarly, referring to another student by the student's sex. Sex has been a topic of some discussion, both in our public discourse and also at the legislature as well. But the legislature has passed other legislation that defines sex as the biological sex identified at birth. And so both of the sex and the legal name are established through various legal documents. And this simply provides that referring to that legal name or the sex as identified at birth is not an unlawful discriminatory practice. One thing to keep in mind is that, again, this is in the human rights section of the code, and so it doesn't necessarily impact other sections of the code. For example, if the use of a legal name or reference to a student's biological sex amounts to bullying, this section, this bill, doesn't address that issue. It doesn't prohibit it. It doesn't allow it. It simply doesn't address other contexts where, outside of unlawful discrimination, where these issues could come up. So it's a pretty short, it's pretty straightforward amendment to the Human Rights Discrimination and Education Statute. Superintendent, if you have any other thoughts you'd like to share, or if you have any questions, I'd be happy to entertain them.
Thank you very much, Rob. We've got someone who's put into the chat. So David would like to know, what about staff? And we all know implementing any rule or statute, there are different ways of having that occur. So if you could share with David, and then I do believe Bailey's also got another question when we finish here. So David is asking, what about staff?
Yeah, no, that's a great question. Staff isn't specifically discussed in this bill. And so I think you would look to those other areas. It could be in Title 49, or it could be in the policies of the district as far as staff behavior. But in any event, staff behavior wasn't specifically addressed by this bill.
So clarification on that, is this adult? Is this adult student? Is this student?
This bill speaks specifically to student. The requirements of Title 49, or this section specifically, talk about discrimination by an educational institution. And so that would be broader and would address issues like adult to adult, adult to student, student to adult, whatever. But this amendment specifically speaks to student communication.
Thank you, David. I hope that.
Actually, I'm sorry, Superintendent, can I make one further clarification?
Sure.
It refers to student conduct. So it could be student to adult conversation. For example, if a student were referring to another student when speaking with a teacher, or a student were referring to another student when speaking with an SRO. So it only refers to the practices, the actions of a student.
Thank you. Bailey.
So, how does this play in part with the school district's anti-bully policies? I know that's been an issue with especially School District 2 here in Billings. Can you explain kind of how that's going to prevent any more bullying from happening with the students?
Yeah, so that's a great question, and one that I touched on a little bit earlier. But long story short, this prevents a discrimination claim under Title 49 for that behavior. The bill doesn't speak at all to bullying under a school district's policy. So those policies can vary from district to district, and they do vary. I can't say for sure how the bullying policy would be enforced, but this bill speaks to unlawful discriminatory practices under Title 49. It doesn't specifically refer to bullying, which is addressed under Title 20 and also under the school district policies.
But do you not see how this bill could lead to that?
Well, I think I understand the question. If one student were to call another student by their legal name, that might not be a discriminatory practice, I think is what you're asking, but it could constitute bullying. And, I could see where that question could come up in different situations, but this bill doesn't address bullying. It only addresses the unlawful discriminatory practices under the Human Rights Act.
Thank you, Bailey. Alexandra, you have your hand up as well.
How will this work within the Department of Education's new 2021 Title IX updates? I'm just wondering if there will be any conflicts within them. I know there's been a lot of changes to those in the last 2 years.
So you're talking about the United States Department of Education and all the recent changes they've undergone?
Yeah, I can send the link. I know that they updated Title IX in 2021 to include sexual orientation and sexual orientation discrimination as within Title IX. So discrimination on the basis of sexual orientation is considered like a violation of Title IX. How will that how are you going to navigate the federal laws that could might be contrary to this bill?
Yeah, so the U.S. Department of Education has issued some guidance regarding implementation of Title IX. They're also going through the rulemaking process. Last time I checked, which was just maybe a week or two ago, I didn't see where they had released the final or adopted the final rules that they were considering. So I can't say for sure what the interplay will be between federal law and state law. But just to be clear, this legislation speaks to claims under Montana human rights law, which are in Montana Code Title 49. We'll have to see what federal claims may be available or what federal regulations may provide once those are finalized by the U.S. Department of Education.
Thank you. And Alexandra did drop she's got the link in the chat box if anybody would like to see that. And again, just to share, this meeting is being recorded and it'll be up on our website like the other ones. This is our 5th community meeting and the rest of the recordings are there as well. Looks like we might have some more. I have one by, I believe, MT Dems Gabe. So Gabe, how will this bill stop bullying and discriminating trans kids?
Yeah, and those are, again, that's a great question. It's very similar to the earlier one. This bill doesn't speak to the bullying policies or to the bullying statute under Title 20. This speaks specifically to unlawful discriminatory practices under the Montana Human Rights Act.
Mm-hmm. Thank you. And Alexandra also just dropped in another press release from the U.S. Department of Ed for proposed changes for the Title IX regulations. That is
and
also.
Sorry, Superintendent.
Yeah, that's good.
And I'm familiar that the U.S. Department of Education has proposed those Title IX changes, but I haven't seen that they've adopted any final rules. Again, when I looked in early October or mid-October, their most recent statement was back in September that they hope to have them finalized in October. But again, I haven't seen the final rules being adopted yet.
Thank you. Gabe has also got that. That's the second part of my question. So understanding then where the Title IX is, I believe, Gabe? I think so.
Okay,
Also,
yeah.
one of the things, the public education in K-12 operates in Title 20. We're in a whole different title here. So one of the things that I know I would ask, if there is discrimination, Rob, then what happens? Because this is not in Title 20. What is there a consequence? And if so, what is it?
Sure. So in general, Title 49, the Human Rights Act, or part of it is the Human Rights Act, does have a process for unlawful discrimination. There are claims that can be filed with the Human Rights Bureau. Those can be investigated, and whatever the outcome is can be appealed either to the Human Rights Commission, or they can litigation can be filed in district court. There's a whole process for discrimination, not just discrimination in education, but discrimination across our state for a variety of different reasons. So what this legislation does is it says that these two very specific acts, student referring to another student by the first student's legal name, or the second student's legal name, or referring to them by the student's sex, that neither of those constitute unlawful discriminatory practice. But that leaves intact, this whole scheme for individuals to pursue discrimination claims.
Thank you. Bailey.
So going back to the legal name thing, so I can kind of understand where you're coming from regarding the legal aspect of things until the legal name change is done, but without the repercussions, so what can the students do to kind of be acknowledged and the aspect of who they are authentically, and try to get some protection with the schools going forward with discrimination, because it kind of is.
Yeah, so the question is, what options are available if an unlawful discriminatory practice claim isn't available? And again, I can't give legal advice, but for example, most school districts have processes in place to address bullying. They have bullying policy, as well as remedies within the school district. And actually some of this will potentially get to the next bill that we look at. Some of those remedies and the process that's available if someone does feel like they're being treated unfairly at school.
Sorry.
Oh, Alexandra, please.
Do you have any concerns that there might be litigation over this with enforcement? In terms of, theoretical examples, if discrimination were to occur, and this is just one of the aspects, one of the now non-discriminatory actions that you've put out in HB 361 are involved in larger case, would they be used in any capacity in building a case of a history or evidence of discrimination? Or even just contact, what do you see as any time that this might happen in the future, if discrimination does happen, do you see this as this discrimination is still being involved in it? What do you see for that happening in the future? Do you think so? Will this action just be in no way have any implications on any processes going forward?
All right, I think I understand the question, kind of with a bit of a crystal ball, what might happen. And so we've talked about the specifics of this legislation, and we've talked about the impact of the legislation, but also some things that it didn't impact. But part of, what I heard you asking about was potential litigation. It's not uncommon for legislation to, at least some of it, to be challenged in court. And certainly there are some of those lawsuits pending for other pieces of legislation from this most recent session. I have not seen any litigation regarding this bill. It's not to say that it's not out there or that it won't happen. It's just, I haven't seen, nothing has hit my radar. So there's always the potential for legislation to be challenged. But, as far as looking forward, I can't say whether there'll be any litigation over this. I do think that there are some other processes in place to address the concerns that I'm hearing. And again, we're going to be talking about one of those processes with the next bill that we look at.
Thank you. So Rob, there's another one. There's two more in the chat. This one is from David. It says, will a school district be liable for this type of student-to-student discrimination accusation? So similar to what Alexandra had.
Yeah, I think that one's a little bit more direct. So a school district, it appears that the purpose of this legislation is to state that that type of behavior is not discriminatory, right? It says it is not an unlawful discriminatory practice for a student to, X, Y, and Z. And so more specifically, I think that it would be hard to make the argument that it is a discriminatory practice when this legislation says that those particular activities are not a discriminatory practice.
Okay, and then I've got another one. I think it's more of a statement, but I think it's important. It's from MT Dems Gabe. It says this bill could cause more bullying and discrimination toward the trans kids in our school. So just wanted to make sure that we have that there. The other one, Alexandra, you have your hand up?
Well, Superintendent, if I can just jump in.
Sure.
I just wanted to mention, this does address the discrimination under Title 49. This bill does not speak to bullying in any form under Title 20 or under the district policy. So I just want to be clear that this bill speaks to the Human Rights Act and to discriminatory practices under that, but does not in one way or the other address bullying claims.
Thank you, Rob. Alexandra.
So I have a question about this bill in terms of its implications upon the authority of school boards. Are you worried that this bill might remove or infringe on local school boards' authority to develop disciplinary practices for students, or is that not a concern?
Well, it may be something, and I'm not privy to those conversations. It may be something that school boards or school board members are discussing with their attorneys. Like I said, I haven't seen any litigation alleging that or asserting that this bill impinges on the authority of school boards, but that's certainly an interesting consideration.
Thank you. We have one from Jamie that's in the chat. Why is this policy necessary? Why does this policy address a minority of students when many of these students already face ostracism and limit their ability to claim the harassment and bullying for being trans?
So the Office of Public Instruction doesn't make law. Our role at these community discussions is to make you aware of some of the legislation that's passed and to have the opportunity to have this discussion. But really the substantive discussion occurred during the session when the legislature went through their whole bill making process. The introduction of the bill, the committee hearings, the conversations legislators had with their constituents. And so all of that, the details as far as what was considered during the drafting and debate over this bill are best referred back to the legislature. And again, the ledge.mt.gov website, you should be able to look through there and find the history of the bill and the argument, the pros and cons arguments that were made when this was being debated.
Thank you, Rob. And one of the things, a reason why the agency, the Office of Public Instruction, is putting these monthly meetings on, these conversations, so that you have the opportunity to really look to see what did happen in that 90-day period during the legislative session, but also to recognize the impact that the legislation has. It's going to be different in any school. This thing here, this law affects post-secondary as much as it affects our K-12 schools. And I believe that these community discussions allow you and everyone that's on here to recognize what these are going to be implemented with, I do believe is what I'm trying to say. So any further discussion? We can move on to the next one. All right, let's go ahead. So Rob, that would be House Bill 504.
All right, thanks everybody. So switching back to the legislative website, this is House Bill 504 from Representative Hastings. I should note that the language of this bill was, unlike the previous bill, the language of this bill was drafted by OPI. And when it was adopted, there was only one minor change that we can talk about. But basically, this bill, like the other bill, speaks to some of the internal school processes that maybe have an external impact. We heard in the discussion of the other bill how things that happen at school might impact people in or outside of the school. This one speaks specifically to if someone has a concern about what's going on in a school, what can they do about it? So this is amending Title 20. It's 20-3-323. And what the bill did is it took a section that requires school districts to adopt certain policies, and it added a requirement that school districts have a grievance policy. Now, most school districts, maybe all school districts, already had a grievance policy, but the impact, or excuse me, the input that OPI was receiving from out in the field is that those policies varied and at times were very difficult for community members, parents, whoever had a concern, made it difficult for them to access the grievance policy. So let's just, and I'll just to show you, there's really nothing else here in the bill. It literally is the addition of this grievance policy requirement. So let's step through and look at what's required of a school district. So it starts off with the trustees shall, this is in sub 1, the lead in to subsection C. The trustees shall adopt a grievance policy that provides for informal and formal resolutions of a complaint. And let's stop there for a minute and think about what that means. That means that you have to have a process to informally resolve complaints that people have before requiring those individuals to file a formal complaint. And so maybe something is happening in the classroom and the parent's concerned and they want to talk with the teacher or maybe with the principal who's overseeing the school. And that would be an informal process, just trying to work it out. And frankly, that's the way almost all issues are resolved in a school district, is informally. But in addition to that, there has to be the opportunity for those individuals to file a formal complaint. So the next requirement in the bill is that the school district policy must inform the grievant about the grievance policy. So if someone has a complaint, if someone has a grievance and they're speaking with the school about it, the school has to inform them about the policy, or perhaps they put the information about the grievance policy in the handbook or other information that goes out to parents. The next requirement in the policy is that the policy that the district provides a printed version of the grievance policy on request. We know that some people in Montana don't necessarily have broadband connections or the tools to print out a grievance policy. And so when approaching the school district, they can request the school district for a printed copy of the grievance policy, and the school district should provide it. And then the final one says, and accepts for filing a formal complaint submitted within 30 days of the completion of an informal resolution. And this is one of the big sticking points before this legislation, where parents had, in some cases, and again, it depended on the district, different districts had different policies, but some districts required parents to file a complaint within 30 days of the incident. And so parents had, from the time that the incident happened, they might not even find out about it till sometime afterwards. You know, maybe their kid takes a while to get around to explaining it because it's embarrassing or whatever, you know, difficult to talk about. And so this provides that 30-day clock doesn't start to run until after completion of the informal resolution. So that gives parents and students and teachers and principals that opportunity to engage in the informal resolution process before the clock starts to tick on the filing of the formal complaint. And so there are a number of tools in here, everything from having that dual process, formal and informal, to informing the individuals about the grievance policy, to providing a copy of it, to providing a little bit of breathing room so that all parties can have that opportunity to try to resolve it informally. There's just a lot in here that addresses concerns that OPI had been getting from the field about how difficult it was for people to approach a school district with issue of concern.
Thank you, Rob. There was, Polly, that was right prior to when we moved to this bill. And it says, wasn't this bill initiated by Superintendent Arntzen, not just a legislative intro? The previous one wasn't. This one we were intimately involved in because of things that have come into our office to balance between school action and parental action. So this bill specifically was one of our legislative asks. And Representative Hastings out of Yellowstone County was very kind. This bill had a very good following all the way through. It had good support from the School Boards Association. We worked with them even prior to the session and making sure that there was not many sticking points with it. But I hope that answers your question.
And Superintendent, from the bill overview page, I pulled up its final vote in the Senate was 50-0.
Thank you. Any hands up, or anybody would like to add comment or a question or clarification? We kind of paired these two bills together just because, not that the previous one, the grievance policy and the adoption would be a remedy to that initial one on discrimination, but it could be in a manner where there is that discussion between the parent and the school district in order to implement a grievance policy. Excellent. Bailey, you have your hand up.
So I was going to ask you, so I know that the grievance policy with the school district is kind of it's a little complicated right now. So if this was with this document here, would it make it, so would the school be able to provide an ease of access to these documents for like parents if they ever requested those?
Yeah,
Okay.
that's a great question. That's one of the explicit requirements of the bill. It's the third requirement. It says that the policy must provide that the school district provides a printed version of the grievance policy on request.
Okay.
So if a parent or a community member, whoever has a grievance, is unable to locate the policy, just knowing that the policy exists, they can request a copy of it.
Okay, thank you. I see that now. I didn't see that earlier, or I might have just not heard it. Thank you.
Yeah, and while we're talking about this bill, I'll just make a quick mention to the one amendment that I'm aware of on the bill, and it's these words "for filing." And the concern that was raised by the school districts is that when it was originally written and said, "and accepts a formal complaint submitted within 30 days, et cetera," they just wanted to clarify as they accept the complaint for purposes of receiving it. They don't necessarily accept the merits of the complaint. And so the words "for filing" were amended into it just to be clear that they accept the complaint document, and but they would have to review it to determine whether they find the complaint has merit or not.
Thank you, Rob. We have another one in the chat from MT Demscape. He asks, could a student ask for one?
Yeah, a student could ask for one. This legislation doesn't specifically address who can activate the complaint or the grievance policy, but it doesn't limit it either. It's in general, school district complaint or grievance policies provide a uniform process for anyone who has a complaint or a grievance about something that's happening in the school. And there's a little bit of context here that's probably important. Under the Montana Constitution, the trustees of the district have the constitutional authority to run the district. Every once in a while, OPI gets questions like, why don't you come in and run our district differently? Our district is broken in XYZ way. And the Montana Constitution provides that authority and that responsibility to the trustees of the district. And so the complaint process typically will have a couple of steps. For example, if you're complaining about a teacher, maybe the first step would go to the principal, and the second step might go to the superintendent, and then the third step, it might culminate in a decision by the school board, because they have the authority to supervise and control the school districts. So that can vary. But at the end of the day, whether it's whatever the internal issue is that's being complained about, whether the complaint is from a student or a parent or whatever, that school district has the ultimate authority. So it's kind of a long answer to your question. It doesn't specifically speak to who can file a complaint, but at the end of any complaint process, the top decision would be with the school board.
Thank you, Rob. I believe the most important part of this is the informal. We want these things to happen as organically and closest to that classroom or the incident where it did. And so putting in the word informal hopefully means that mediation occurs very close, and rather than going through the formal. The other part of the question that I have then, Rob, is after this process occurs, then what? So let's say there's not satisfaction. Is there an appeal? Is there a process? And where does that go from here?
So yeah, that's an interesting question. It goes to you eventually, potentially. So Montana law in Title 20, you would have to look under Title 20, Chapter 3, has the powers of the various elected officials. And so it's within the power of the county superintendent. Each county has a superintendent. It's within the power of the county superintendent to hear appeals from the school board decisions. And it's also under the state superintendent's power, the power to hear appeals from decisions of the county superintendent. And so those describe a process that theoretically could be appealed from the school board to the county superintendent to the state superintendent. This has a lot of implications, not the least of which are, as chief legal counsel for OPI, we can't offer legal advice or, on issues that are happening at the school district level, because it potentially creates a conflict if we then have to sit in judgment of whatever that whatever action was taken based on that legal advice. So there are some interesting things, and we do have appeals that come up from time to time from the local level. I should note that there are some Supreme Court cases about this that limit the authority of that appeal. But nonetheless, those are fun conversations to have with your legal counsel about what the law requires for a process, and what the Supreme Court has said about that.
Thank you. So within my term in office, we've had very few, it's not uncommon, but we've had very few that come up to me. If indeed that solution isn't something that there is an agreement with, that appeal can also go up to district court and then follow up that process. But I come back to that informal, because to me, that's where processes and solutions can occur. There is something from David in the chat. It says, is informal mandatory? When does the clock start?
Yeah, so that's a great question. Informal has to be allowed under the policy, and I'm not sitting in judgment of what that looks like. It could, theoretically be a short conversation between a principal and a parent, or whoever. The parent asks for something to be dealt with, and the principal says that their hands are tied, or whatever. I'm just making that up, but it could be a very abbreviated process, but that has to be available to the grievant. And as far as the timing goes, this doesn't speak specifically to the timing of the initiation of the informal process, but this legislation makes sure that there is that 30-day period from the resolution or completion of the informal process to the requirement that it be filed as a formal complaint. That formal complaint process isn't outlined in the statute, so that you'll want to be sure to look at that grievance policy to make sure that you meet the timing and the filing requirements for the district.
Excellent. Anybody else have anything to say about this bill? Perfect. I don't see anybody. Is there anything in the chat? I don't see that there's anything in the chat as well. Rob, anything? I'm going to let you have the last statement over these two bills.
Yeah, I'll just, these two bills are interesting because they both speak to things that happen in school, and they both speak to how that, could impact remedies outside of the school. And so, always trying to, the legislature, or certainly with our grievance policy legislation, trying to refine the process and make it accessible to people. There are going to be, disagreements over policy, disagreements over what the right approach is, but these both speak to, there's a similar theme, even though they speak to totally different things.
Thank you, Rob. Well, everyone, thank you for joining us tonight and being part of this discussion. Again, this is a listening session. This is a questioning session. This is just trying to see how we can implement this to the best of our ability across the many different school districts that we have across our state, and of course, putting all students first. Blessings to you tonight. Stay well. Rob, question?
Yeah, the one thing I saw a chat comment pop up.
Okay.
I just wanted to be clear that
Sure.
OPI doesn't implement either of these bills. Both bills are implemented in other agencies. The bill regarding the complaint policy that a school district must have is implemented at the school district level. And the bill regarding the unlawful discriminatory practice is a limitation on claims that can be filed with the Human Rights Bureau. They're important to discuss in the community forum because they're issues that are of interest to people, but OPI doesn't directly implement either of these bills.
Thank you for that clarification, and thank you for putting that into the chat, Alexandra. With that, everyone, please stay safe. Please stay warm out there. And there are a lot of Montanans across our state that also need that helping hand. Blessings to all. Bye-bye.